May it please the court, my name is Amy Shield, and I represent the appellant, former husband David French. I would like to reserve 3 minutes for rebuttal.
Thank you.
This case...
Ms. Shield, I have a question for you right off the bat. It appears that our decision, this court's decision in Lindstrom versus Dorgan, in some ways sort of eviscerates some of the positions that you were taking, in the sense that, as you may recall, Judge Farmer argued strenuously in the dissent that the new statute, 61.411B, was intended to change the law for modification because people were in supportive relationships or cohabitating. And the majority rejected that and adopted what the trial court said, which was the statute was simply a codification of what the law has always been, which is if you can show that there's been a change in circumstances to warrant a modification, then that's the law, and that this statute has done nothing more than that except to assist in trying to figure out what factors one might consider in determining whether there was a supportive relationship that would warrant a change in circumstances to warrant a modification. And you seem to suggest that we ought to be looking at the statute from the standpoint of a different standard. Could you address that, please?
Yes. Obviously, we agree with Judge Farmer's dissent quite strongly, and in our brief we've addressed the purpose of the statute through the legislative analysis that clearly stated its intent was that the provisions provide an alternative method to the court to reduce or terminate alimony without having to find that there's been a change in financial circumstances as is in the current law. And we also argued in our brief that you have to consider that we already had on the book 61.16 subsection A, which concerns or requires the court to consider the financial circumstances of the party. The supportive relations statute, we maintain, creates a new right for the court to reduce or terminate alimony if there's a supportive relationship. And so it's not a duplication of A, which is what this court appears to be doing in the Lindstrom case.
Well, we had the case out of the second district court, Buxton versus Buxton, which sort of adopted the argument that you're making, and this court, and I believe one of the members of this panel was on that decision.
Correct, Judge Taylor.
Judge Taylor rejected the Buxton analysis, and if that's true, if this panel is bound by this Lindstrom decision, in order to change it, we have to bank it. So, assuming that we don't do that, what do you do with it now? What's your argument now? Can you still win in light of Lindstrom?
Absolutely, in light of Lindstrom. First of all, what I was starting to say initially is that this case should shock this court's conscience because it's legally, equitably, and morally indefensible. And the facts in this case are totally distinguishable from Lindstrom. First of all, in Lindstrom, at the time that it was decided, it was only a 5-year marriage. In this case, the former wife has been involved in a conjugal, exclusively monogamous relationship with Arthur Bradford for 21 years, since 1987. And this is a marriage in every single respect except for the license. And this marriage is longer than the former wife's marriage and most marriages in general today. In the Lindstrom case, the former wife was barely in the same position as she was at the time of her dissolution. Her wealth had not accumulated at all. In this particular case, the former wife had her forensic accountant who testified and issued a report that compared the former wife's assets at the time while the marriage was still intact to the assets at the time of the hearing in 2006. And the evidence showed from the report from her own accountant that her net worth increased 9-fold from $97,000 to over $900,000. At the time of the dissolution, she had just $12,000 in cash. This increased to $170,000 in cash. At the time of the dissolution, the wife had no retirement account, which is a misnomer in this case because she chose not to work full-time since 1979. And when they asked her the question, do you intend, you don't ever intend to work, she said, exactly. And that's also a big distinction between our case and the Lindstrup case, because there the former wife was doing everything possible. She was working to her capacity, and yet that was insufficient to meet her needs. Here, the evidence shows that her liquid assets have totally grown from $12,000 at the time of the divorce to over $550,000 while she's still receiving alimony from the former husband. And we did the math, and the more than $550,000 that she now has equates to approximately approximately 70% of the $780,000 that she received in total alimony from the husband. And thus, in this case, the former wife's alimony payments have enabled her to fund an improper savings component because of this huge growth that she's had from $12,000 to over $550,000.
What is the best case that you have if we assume that the 61.14B hasn't changed the landscape at all? What is your best case for the proposition that the trial court found that Mr. French had the financial capacity to continue to make $3,400 per month alimony payment? What is your best case to suggest that under the circumstances as to how her assets and lifestyle has grown warrants a change in the alimony payments that Mr. French is required to pay?
I think that in answer to your question, you can look at any selection. Even the Linsgrove case would support our situation, but we also have the Buxton case or the Donoff case that would support this. Because in our situation, and I think you have to look at the total framework. When you're looking, as this court is, and reducing alimony, you only do not look at the former husband's finances, but you must look at the former wife's. And in this particular case, the former wife can afford to pay her expenses because of the substantial savings. She has no mortgage, no debts. She lives rent-free in Bradford's home 6 months of the year, and he lives 6 months of the year in her home. And I think that's also a distinction in the court. And even when we apply the Linsgrove case, when you look at 6114, you have to look at the relationship that it's economically equivalent to a marriage. And here it is. There is this financial interdependence. She is affording him the benefits by him living rent-free in her house, and vice versa. He is affording her the benefits when she is living with him. And I think, you have to look at this in the total picture and apply what has happened before in this case in order to fully understand it. Because earlier, the former wife was living with Buxton for several years, and he was paying her rent in an earlier home that she lived in. $300 in rent and the $300 in doing other chores. And they went before the court, and the court said, you know what? I'm going to reduce the alimony, that was $4,000 at the time, to $3,400. I'm going to take that $600 off, the $300 for rent and the $300. So now they've learned from this last experience. And so they have used this or manipulated the payment of her expenses to portray that there's an alleged need for her to continue alimony, when in actuality she's enjoying a more lavish lifestyle because she has 2 houses instead of 1. And so she's going in this fiction that he doesn't pay me rent, I don't pay him rent. And using that as a basis for them to have the 2 homes. And no longer, because they know that it doesn't work to the court to say that he's paying her rent, now they say, well, neither of us are paying each other rent, we're just enjoying both of the homes. And
well, what would be your, if we agreed with you, what would we do? We say, judge, go back and divide it in half, reduce it at all, eliminate it?
I think
what kind of instructions are we going to give the trial court if we were to agree with you? What do we say to the trial?
I think that the court needs to reduce it. I think in this particular situation that it should, if the court doesn't think that it should be eliminated, and I think it can be, because after 21 years there's been testimony by Mr. Bradford at the trial saying that if she would never experience any kind of financial devastation if her alimony were terminated completely, because he testified that she would still be able to live in his home and that things would not change from their relationship. And there's a history of this. When her home was being built for the 1 year in 1995, she lived for a full year in his house and he paid for everything. So we have a history here, and I think you have to look at all the elements again.
You're suggesting that we not say to the trial court, the statute says you may reduce or eliminate. We should say to the trial court, you must eliminate the alimony because clearly she's in a supportive relationship that amounts to a marriage.
Or in alternative, to reduce it to $1.
Why? What's the basis? What do we say that for?
Well, if you reduce it for, we of course espouse that it should be eliminated, but if you reduce it for $1, that would take, in effect, if their relationship ever ended, if he died, if whatever might happen, then she still would have the ability to come back with $1, like Zebulos, like they did in Zebulos. But our position, obviously, is for it to be terminated because she is, in every single respect, in a marriage. And, I mean, you can even look at their long-range planning. She's in his will, and he's in her will. He's named her in her living will as a decision-making, affording his treatment. They have a joint checking account for each to pay the other's bills if either becomes incapacitated. They have jointly owned property, the car that they own jointly, the insurance. Again, the court, what I think was an error in effect, by failing to impute any income to the former wife by her bettered lifestyle, by being able to live 6 months of the year in his North Carolina home, or for him living with her, because the wife's forensic accountant testified that income is imputed to someone who's living free of charge. And the case law instructs us that the receiving ex-spouse, when they provide room and board to a new partner, is evidence that the fair market value of those and other contributions is some measure to the extent to which periodic permanent alimony is excessive. So looking at it within the framework of the financial circumstances only, you have a situation, in summary, where the former wife's assets have ballooned from $12,000 to over $550,000, while she was able to live in 2 homes, while she was married, she only has 1 home. And all of this is made possible. She has a full conjugal, intimate, 21-year relationship, and our brief on pages 4, I think, through 15 goes through fact after fact after fact, which shows that there is a supportive relationship under the statute. Financially, she does not need the money. And taking the worst assumption, yes, she does need some of the money. This court denied any reduction whatsoever. It was almost like an all or nothing proposition here. And again, the testimony shows that should the court remand it back and terminate her alimony, you have the testimony of Mr. Bradford saying that nothing's going to change. He'll take care of her. And in fact, in his will, he left her his house and the substantial portion of his 401k, which was like $225,000 and $230,000. So a small amount will go to his brother and his brother's children, but she gets the bulk of it. So she is protected. And you have to also look at it from the former husband's standpoint. It is a travesty that he has to continue to pay alimony while she is living with another man and in a 21-year relationship. In the pre-statutory cases, the court in Lowry stated, "We expect too much when we require a person to support an ex-spouse who is married, quote unquote, either legally or illegally." This case cries out for this court to reverse. And we request that the court do just that.
Thank you.
May it please the court, Jane Bursell Walsh on behalf of the former wife Gail Smith with me as my trial counsel.
Ms. Walsh,
I'm
I'm somewhat stunned by this order. It's strikingly to me appears that Ms. French is living a lifestyle that is greater than she had when she was married to Mr. French. She has 2 homes. She has a vacation home. She has a home in DeLand. She flies free. They vacation together. It appears to me, irrespective of what Judge Cook found, that we have a situation where these people are, in fact, in a marriage, and they're just doing what they believe to be technically sufficient to make it appear from a technical standpoint that they're not. Perhaps you can enlighten me on that.
With all due respect to what you just said, the trial judge was in the best position to decide the facts, and he did. But let me address the elements that you're concerned about. First of all, the trial court addressed the fact that they are living in each other's homes and said that while she may be living 6 months of the year in North Carolina, the fact of the matter is that she still has to pay all of the expenses on her home in DeLand for the entire year, regardless of where she's living. It's no different than if I went and lived in somebody's home for a while and I didn't pay them rent. In terms of her assets having increased, there's a finding in the final judgment that yes, her assets have increased, but it's a product of market forces attributable to the fact that she did well selling the property that she received in the divorce. And yes, she has a retirement account, but her retirement account consists of those proceeds. Those are money she received in the divorce, and she's not required under the law of this state to deplete her capital assets in order to support herself. The trial judge did a yeoman's job in a 12-page final judgment of detailing not only every single factor in the statute, but going through in a separate provision the reasons why the court finds that she still has a need. The trial court was very specific to say they do not, neither of them pays the other rent, neither of them shares expenses with the other. They are not drawing on each other's bank accounts. The estate provisions that she's speaking.
How would that be different than if you had 2 income families? I mean, if people were married and they had 2 incomes and they decided, well, I'll take care of these bills, you take care of that bill, I'll take care of my American Express account, you take care of your American Express account. How is that any different?
I don't think it is different. But under the statute, the courts say, and this court in Lindstrom made it very clear, that you have to prove financial interdependence and that the receiving spouse no longer has a need for the support. So the arguments that you're making are arguments that would be relevant perhaps in the 2nd District in Buxton, and maybe in had we not had this court's decision in Lindstrom. But Lindstrom very plainly says, and let me just remind the court, unlike the 2nd District Court of Appeal in Buxton, which determined that economic impact on the obligee was only part of the analysis in determining if there is a supportive relationship, the trial court in this matter concluded that Section 61.141B requires a relationship economically equivalent to a marriage. We adopt the reasoning of the trial court. The statute is clear in this regard. The financial aspect of the relationship is what this court has to be focusing on, and it is what Judge Cook focused on in reaching the ruling that he did. The arguments that they're making to you today are arguments that are inappropriate in an appellate court because they would require this court to reweigh the trial court's factual findings, which you cannot do. And the reason you can't do it is because there is competent, substantial evidence to support the findings. They didn't put on a forensic expert at trial. We did.
I'm having a little trouble with that last statement. If Lindstrom says that our review is whether there's competent, substantial evidence, it seems like to me that we do reweigh it. I don't understand that. If we say, if we don't find, we look at, I mean, my problem is, and you may be right, but my problem is I'm reading this order, I'm going through this order, and I'm thinking when I get to the end, Mr. French is going to get some relief, and then suddenly he doesn't. And I'm just, I think that there's more. I guess I would like you to tell me how much more would these people have to be interdependent and supportive of each other before it would trigger a reduction?
I think there would have had to have been some financial interdependence between them. They would have to have been, for example, in the Zabalos case that Judge Taylor was on from this court said the supportive relationship is sufficient to reduce or terminate the alimony because the former wife's fiance was paying all of her expenses. Same thing in the Donoff case. Supportive relationship, they're remand back to the trial court because the evidence here is that the former wife no longer has a need because her live-in cohabitor is paying her expenses. That is not what we have in this case.
Well, in 1992, some trial judge reduced it from $4,000 to $3,400 based on some of the things. Sounds like to me it's only gotten better for her. You see, I mean, it seems like that her circumstances in terms of her need for the alimony has gotten less and less since 1992, and it appears that some trial court, upon a motion for modification, reduced it. Now, what, 18 more years? I mean, about 20 more years have gone by?
Number one, the circumstances were different in 1992 when
How so?
Well,
Mr. French's income was better then than it is now.
Mr. Bradford was providing services and rent to her. He no longer is providing any services to her because he suffered cancer in the interim and he was no longer able to provide those services.
Like what kind of services?
He was mowing the lawn and doing household services and things of that nature. Then Judge would have put a monetary value on those services and use that to reduce the alimony. And he was also paying her rent, which is no longer true. What was the second part of your question? I'm sorry. How her circumstances have gotten so much better. She has no source of income other than her alimony. The evidence in that regard is undisputed. She has a CD, which is a very small amount. It's in the former wife's exhibit. You can take a look at it. Her only source of income is her alimony. That was undisputed. They did not put on any contrary evidence. She testified that if the alimony were reduced, she would be financially devastated. She would have nothing to pay her bills. So this case, unlike the cases that I just mentioned to you, it proves that the trial judge was correct in finding that her need has continued. Mr. French had the burden of proof, and he did not meet that burden of proof. And in terms of the standard of review, Your Honor, you will see in the Lindstruff case, this court does three things. It first does a de novo review as to the statutory factors. It then looks at whether or not competent substantial evidence exists to support the findings as to those 11 factors. And then on page 4 of the opinion, the trial court says, and I quote, "It was within the trial court's discretion to weigh these factors and reach an ultimate conclusion." So I think this is one of those instances where you have actually 3 standards of review involved. This final judgment passes muster regardless of which standard you use. And as I mentioned before, it's inappropriate to ask this court to reweigh the facts. The 12-page final judgment appropriately made the findings, and it's our position that the final judgment denying modification should be affirmed.
Was there any suggestion that there should be some income imputed to your client?
No, they did not put on any financial evidence, Your Honor. The only forensic accountant came from us. That was it.
What was the duration of her marriage, the marriage of the Frenches?
I think it was between 18 and 20 years, as I recall. And this relationship, Your Honor, was not 21 years. The Judge Cook found in his order that the duration was 16 years. However else it may work out, I'm not aware. I'm only aware of what the judge said in his final judgment.
So the trial court here, I don't know if he made a specific finding that this was a supportive relationship, but did he implicitly make that finding that this was a supportive relationship, but that the wife had a continuing need for alimony?
I think you could interpret it either way, because he did not come out and say, I find this is a supportive relationship, or I find that it's not a supportive relationship. But we do know that from this court's decision in Lindstruff, it doesn't really matter, because even if he found that there was a supportive relationship, you still consider need. He considered need and found that there was still not a basis to warrant modification. And there is nothing in the statute itself that requires a discrete finding that there is or is not a supportive relationship. What it requires is findings as to the 11 factors. I think my reading of this judgment is that the trial judge found this is not a supportive relationship, and the reason I say this is because if you look at all of the financial elements that he reviews and then his need findings, there is not economic equivalent of a marriage relationship here, and that's how the supportive relationship is
But,
defined.
you know, as Judge Azuri pointed out, it certainly seems to be the economic equivalent of a modern marriage, because when you have households where both spouses are working and they maintain separate accounts in many instances, they're responsible for certain household bills. In many modern marriages, the spouses do not open and maintain joint accounts. It certainly appears to be equivalent to a modern marriage.
That may be true, Your Honor, and if that's something the legislature feels should be factored into the statute, then it's up to the legislature to amend the statute and change the elements. But as they exist right now, the judge did the appropriate analysis.
Well, let me ask, since you brought up the interpretation and implication of the statute, Judge Farmer makes an awfully compelling argument that if this was, why would this simply be considered a codification of law? If your position is this is the way it's always been, it's no different than it was before the statute makes no impact, what sense does it make that the statute was passed if it wasn't in fact an effort to say, now that we as a society, state of Florida, has now recognized that we no longer want to put up with the fiction of people cohabitating together, when the alimony would end upon remarriage, when it effectively is a marriage, for all intent and purposes, it should be eliminated. What would be the purpose of that statute? I mean, the legislature doesn't normally go around just simply codifying the common law. They do occasionally, but not with great regularity.
I have two responses. First, this court in Lindstrup has said that it's a codification of prior law. But you do raise an interesting argument, and it's something I've given a great deal of thought to. And frankly, Judge Farmer in his dissent answers his own question, because he finds that pre-amendment, the existing law in Florida did not permit a trial court, if he or she found that there was a de facto marriage, to terminate alimony. And that this statute is a change in the law because it now authorizes a reduction or a termination if the court finds that a supportive relationship exists. So the statute does have a purpose other than, more than simply codifying the pre-existing law. Unless there are any questions?
Well, let me just ask one other. Would it be your position then, as far as the question that I posed about them and that has been re-asked by Judge Taylor about the modern marriage? Mm-hmm. Are you then saying then that even if we accept that as a principle, that her income that she uses, and like in a modern marriage, is the $3,400 a month she gets from Mr. French?
That's the only income she has. That is her only income. Okay. Yes, Your Honor. We will submit that the final judgment should be affirmed. Thank you.
Thank you.
I'd like to briefly clarify some points that were asked, and then just touch very quickly on the 6114 1B3, the financial interdependence. First of all, if the court just looks at our wife's Exhibit 725, this is the Julie Hirschman's, one of the pages in there. I want to correct that that she said there's just a small CD. She shows that there's sheltered savings of $383,362, in addition to $169,968 in cash, which comes out to $553,362. Secondly, for Judge Taylor's question with regard to the length of the marriages, they were married, Mr. and Mrs. French were married for 18 years. She started a relationship with Mr. Bradford in 1987. However, he moved in with her. He had been up in Atlanta working for Delta Airlines and moved in with her in August 1990 in her home. And so at the time the final judgment was rendered, which was 2 years ago, that would be 16 years. If you add today, it's 18 years. If you add the total time that they had a monogamous, conjugal relationship exclusively with each other, that's where we get the 21 years. Then finally, I wanted to just touch, I do not believe that it's implicit in the finding as far as whether there was a supportive relationship. I think that the judge, we brought this case under that statute specifically to find out or to maintain, and we believe that we proved by the preponderance of the evidence that there was a supportive relationship. The judge erred in not making that finding, and that again is a legal error that he made that is reversible. And then finally, touching on the financial interdependence, it appears that the former wife's position is that this is an all or nothing kind of situation. And she cites to the cases where, or makes the argument, where the wife is being fully supported by her cohabitor. You don't need to have an all or nothing. The way the statute reads, relationship economically equivalent to a marriage. So you look at it if there's financial interdependence, and clearly there is in this case. Simply just look at them 6 months and 6 months not paying. She has a benefit of 2 homes, and he's paying for half of it. She's paying for half because of the 6 months that they live with each other. He's loaned her money, $41,000 to put the down payment on the house. He gave her $7,500 to fix the house, and also they own joint property. So there's financial independence that way. In conclusion, we maintain that the facts of this case are a poster child for the implementation of the supportive relationship statute. We feel that that it is totally inequitable for the former husband to continue to pay this $3,400 monthly in alimony while his ex-wife lives in this long-term, 21-year supportive relationship with another man and is able to increase her net worth from $97,000 to over $900,000. Thank you.
Thank you.